While data security experts are urging employers to safeguard employees' details, it comes in the wake of several high-level data breaches at various companies. Experts say if the Protection of Personal Information Act isn't applied properly, companies could also pay more to train staff on personal data management. So to tell us more about this, we're joined now by Advocate Tertius Wessels from Strata-G Labour Solutions. Tertius, thanks a lot for joining us this evening. Now, is it true that most employers are not grasping the far-reaching consequences of how they collect, store, as well as dispose of information, and how so?
So I think the expression "no good deed goes unpunished" has never been more appropriate than in the case of Popi. Popi does not require intent or negligence on the part of an employer in order for that employer to be held accountable and liable at the end of the day. We all have come to know and understand over the years the common law doctrine of vicarious liability, in terms of which an employer can be held accountable for any wrongful acts or omissions that have been committed by their employees. Now, although Popi in itself is not considered labour legislation, it does impose certain strict liabilities upon employers, and it regards the employer as being the responsible party. Now, if we look at those liabilities that are created in terms of the Popi legislation, you almost get a certain form of statutory vicarious liability, in terms of which an employer will then be liable for its employees' wrongful acts or omissions committed in terms of Popi.
Sure. So now we're talking about liability exactly from a practical perspective. What constitutes as liable? How exactly are they going to be held liable for employees' behaviour?
So there are various provisions contained within Popi, and in order for it to identify as a form of non-compliance, one would have to first and foremost see to what extent employers have gone about the process of trying to be compliant. We all know and understand that the primary objective is to protect individuals and to ensure that no harm is caused to those individuals. And this all stems from the fact that employers need to ensure that an information officer is appointed, that that information officer conducts a risk analysis in order to determine where the employer is getting information from. Why are we processing that information? What is the purpose that we're processing that information for? Because ultimately the legislation creates two forms of legal consequences or penalties for employers. The one would be a fine or imprisonment, which can be anything from 1 million rand fine up to a 10 million rand fine, or 1 year to 10 years imprisonment. But besides those legal consequences that result, there's also the reputational damages that businesses can suffer, the loss of potential customers, a distrust that employees have in their employers. And those are far more costly for businesses and employers at the end of the day.
Yeah, and from a point of non-compliance, how exactly is non-compliance measured? And I'm looking particularly here by information regulators.
So the information regulator is obviously an independent third party that will be conducting inspections, very much like the inspections that are being conducted by the Department of Employment and Labour, whereby normally complaints would get raised by a particular data subject in respect of non-compliance, and the information regulator would then have to embark on an exercise of conducting an inspection in order to determine whether or not, first and foremost, there's any legitimacy in the complaint that is raised by the data subject. The information regulator will then also, in terms of a code of conduct, issue a notice of non-compliance to employers or businesses and give them an opportunity to remedy those non-compliance areas that have been identified, be it the fact that non-compliance is occurring because unauthorized third parties are gaining access to information, there are inadequate security measures in place, etc.
Are organizations in South Africa, Tertius, still a little bit naive about whether or not the Popi Act actually applies to them? I mean, there's still an assumption that if you're not in the IT industry or data or banking company, that, you know, you're the only one, or they're the only companies that are actually affected by the Act. Is there still that kind of assumption that continues to resonate in the South African context?
Yeah, so when it comes to looking at why we are getting information, I think first and foremost, South Africa has recently been experiencing some of its biggest data breaches that we have seen. It's not so new for other countries around the world. And it is therefore important for us to ensure that not only as the responsible parties that are processing data, that we put the necessary measures in place to protect the individual's information, but that we also inform the data subjects or consumers or employees of what their rights are in terms of Popi legislation specifically. Because we all need to know and understand that we can only protect our own interests and our own rights provided that we understand what it is that we are entitled to do. So data subjects should be entitled to access information. They should know who's processing their information, who's gaining access to their information. Has there been a breach of some sort? Because only then we can know how we can go about protecting our rights.
Tertius Wessels from Strata-G Labour Solutions. We'll leave it there for this evening. Thanks a lot for joining us, shedding some light on that very particular and important matter around protecting your own information as well as this Popi Act.